Alright, so this is Chapter 8, and in Chapter 8 of the U.S. government, we're going to be covering the judicial branch. And remember, there's three branches: the executive branch, the legislative branch, and now the judicial. So the goals for this chapter are to identify the judicial branch can decide if the Constitution is being followed, to explain the types of cases heard by federal courts, to describe the difference between a district court and a court of appeals, and to explain how the United States Supreme Court works, to describe the importance of the Supreme Court's decisions, and then last, to explain how the Supreme Court can bring changes to the Constitution. Be sure to have a pencil and paper, take notes, and there will be questions following. Let's talk about the judicial branch. The judicial branch is found in Article 3 of the Constitution. But, it didn't come right away. The Articles of Confederation, our original Constitution, the beginnings of our Constitution, did not work because it did, for many reasons. Well, and one of the main reasons is it was just the beginning of developing a Constitution. And a Constitution, if you look at the root of the word constitute, it means what something is made up of. So in their description of what the government was to be made up of, they were beginning to develop the ideas of that. So the Articles of Confederation was more like a skeletal structure, a rough outline of government. And so they realized that we did need a system of justice. So Article 3 of the Constitution set up the third branch of the United States government, and that was the judicial branch. And when you think about judging, it's not necessarily a negative thing. It's about weighing the behavior of someone against law. So it's establishing law and following it through. So judges are very wise and critical in examining law and interpreting law. The judicial branch includes all federal courts, okay? So there's three main federal courts. The first is the district courts, and we're going to go into detail on all these so you really understand. The second is the courts of appeals, and then the last, the Supreme Court. Supreme. You ever order a taco Supreme? Supreme meaning the utmost, the greatest court. So the most important court is the Supreme Court. The Supreme Court is in Washington, D.C., and it can decide if Congress or the President have acted according to the Constitution. Okay, so it's a checks and balances. They make sure that they're following the Constitution, and they can decide if certain laws should be made or not. So the federal courts are set up to interpret or explain the meaning of the United States Constitution. And as time evolves and as we grow, we interpret the words of the Constitution in different ways. And let me give you an example. Freedom of speech for a 3-year-old is different in meaning than freedom of speech for a teenager is different in meaning in freedom of speech of a 60-year-old. So as we grow older and mature, these meanings and the way we interpret freedom of speech can change. For instance, a teenager might say freedom of speech for me. It might be kind of a narcissistic, self-centered freedom of speech, not considering the impact their speech has on others. And as you mature, you realize your freedom of speech also includes a responsibility of how your word impacts others. So it's not only a freedom, but a responsibility. So the cases that violate or break a federal law are heard in federal courts, and they interpret the law and follow through when they examine these cases. So the federal court system includes the district courts, as you see at the bottom here, the Court of Appeals, and as you climb up to the very top, it's the Supreme Court. So what are federal district courts? Federal cases are heard at district courts. So each state has at least one district court. And if you look over here, there's California, and California has 4 district courts. Why? Well, because California has the largest population, so it's going to have more district courts. There are a total of 94 district courts and more than 600 judges, and I'm talking about throughout the nation. Some larger states are divided into 2 or more districts. Our example, California. In that case, each district has its own court. Several judges are assigned to each district. District courts are the only federal courts that use juries, and juries are regular citizens listening to the case. Okay, and in most other federal courts, the judges make decisions without juries. And soon enough, you'll be called to jury duty. Trust me, I've been called at least 6 times already. Each district has a chief judge, okay, and I chose as an example the 36th District Chief Judge, Kenneth King. Okay, so each district is given a number, and the 36th District is just one of the 94 districts. And most cases are heard by a judge without a jury. However, other cases such as bank robbery, kidnapping, tax evasion, or counterfeiting money are tried by a judge and a jury. So there's certain cases that are tried by a judge and a jury. When a case comes to a district court, the judge explains to the jury. Okay, so say you're in the jury, the judge is going to sit down and talk to you about the law that the defendant was accused of breaking. So you might say, or she might say, this defendant robbed a bank and he broke such and such a rule and such a law. So then the jury decides if the defendant is guilty or not after hearing the case. If the defendant is found guilty, the judge decides on the sentence or punishment. So he determines what's going to happen next. So what cases are heard in federal district courts? The Constitution, it's in the Constitution, so if you were to really dig in, you'd read that the federal courts have the authority to hear cases that involve, so if you look at the bullets, a person, group, or company who disobeys any part of the Constitution, including the amendments. A person, group, or company who breaks federal laws passed by Congress, such as tax, postal, banking, or military laws. For instance, we learned earlier that one of the postal laws is you cannot mail hard liquor to your friends. Okay, so you would be heard in a federal district court for mailing hard alcohol. A foreign nation that sues the United States or a U.S. citizen. Okay, so a foreign nation can sue a U.S. citizen if they're on foreign land. They take them and send them back to us, and they hear the case in the United States. That might be something for you to know. Maybe you go to Mexico and have a wild night out and drink too much tequila and violate some laws. You'll be sent to the U.S. You should be sent to the U.S. and tried in a federal district court. They try a foreign nation, or I'm reading the same bullet. The next one, an ambassador accused of breaking the law of the country where he or she is serving. And if you recall, under the Department of State, there are ambassadors who are supposed to be representing the U.S. in developing good relations with other countries. So, for instance, if there's an ambassador in Kenya and the ambassador stole some money from a store, they would not be tried in Kenya. They should be sent to the United States and tried in a federal district court. A crime that occurs on an American ship at sea or on federal property will be tried in a federal district court. Disagreements between states, so 2 states can battle it out in a federal court. Lawsuits between citizens of different states. Okay, so if we're in California and we have an argument with someone in Ohio over, say, land or who knows what, We'd be off to the federal district court. There are many other federal claims courts, so I'd call them, with my own language, sub-courts, sub-federal courts. So there's a federal claims court, and it involves money claims against the federal government, and a decision in favor of the person bringing the suit usually results in a sum of money being given that person. Also, it deals with approximately 1/4 of the cases before the court that involve tax refund suits. So if you're really angry, say you own a business and you feel like you don't owe as much as you should, you'd go to federal claims court. The Court of International Trade hears cases where individuals and businesses have issues regarding taxes collected by customs officials on imported goods. So say you have an import company and you love African masks made by some great tribe, and they tax you up the wazoo at customs to get it to the United States. You would take it to the Court of International Trade. There are also territorial courts, which hears people who live in U.S. territories. Now, what is a U.S. territory? There's a part of the U.S. is not included in any state but organized a separate legislature, and I'm thinking of Puerto Rico. It's not exactly a United States state, but it is territory, and they have their own lawmaking body. If you're an inventor, pay attention to this one. It's the Court of Customs and Patent Appeals. So it hears cases appealed from the Court of International Trade, one of the courts we just talked about, from people applying, or it also hears from people applying for patents and from people whose patent rights have been violated. So say you invented this really amazing nail clipper that captures the nail clips as you clip them, and some jerk up the road found it and was copying it and making money off your nail clipper invention. Well, you take that to the Court of Customs and Patents. The tax court is yet another federal court. Guess what they hear? They hear appeals concerning payment of federal taxes, and trust me, they're busy. This court does not hear criminal cases but settles disagreements about the amount or type of tax. So you might notice that I keep talking about appeal. So this word means to apply for review of a case or particular issue to a higher tribunal or a higher court. Sometimes, maybe in the C's, I'm not sure that this happens often, you can appeal, write an appeal, say you were accused of something. So basically what you're asking is for your case to be reviewed and for someone to assess the situation more clearly. It's always nice to get a bit of a perspective on what we're talking about when we talk about the courts. So again, the greatest court of all is the Supreme Court. It's the highest court in the federal system. It's in Washington, D.C. Okay. After that, underneath that, is the Courts of Appeal. And as you recall, it's an intermediate level in the system. There are 12 regional courts, and they're called circuit courts. Like if you've ever looked at a circuit board, there's these different connections. That's kind of what they mean by circuit courts. After that, the third one is district courts. District courts are the lowest level in the federal system. There are 94 judicial district courts. Remember that map of California? We had 4 district courts in California. There are also the courts of the District of Columbia, and then there's also military courts to review military cases, and then the Court of Veterans Appeals. Okay, so now it's time for a little review to check on your understanding. So write the word from the word bank that best completes each sentence. And then you're going to go on and answer what you think. And please provide thorough answers. So we just reviewed the levels, the Supreme Court, the top next is the United States Courts of Appeals. So let's talk about the United States Courts of Appeals. Accused people who feel that their trial was unfair in a district court, the lowest court, they may appeal or ask a higher court to review their case. This review takes place in a court of appeals. Congress set up the United States Court of Appeals in 1891, so it's been around for a while. These courts handle appeals from the district courts. So these courts also hear appeals made by federal regulatory commissions, and we reviewed the regulatory commissions earlier, which are below the departments. How are the courts of appeals organized? Well, there are 50 states divided into 11 large judicial areas called circuits. There is also circuits for District of Columbia and a federal circuit that involves federal agencies. So the U.S. is divided into 13 courts of appeal. Okay, I think we've covered that to my liking. So, how does a court of appeals work? Well, when a court of appeals gets a case to review, the judges study the history of the case. 3 or more judges do the following. They review the legal procedures involved in the case. So, how did the prior court follow their legal procedures? And then they interpret the laws. So they look at whether the laws that were being used, and they determine what it means in the particular case that they're reviewing. They cannot ask for new facts in the case. So they review only issues of law. So they're basically reviewing to ensure that the prior court was following the law and is using the law, interpreting the law in a way that is constitutional. After that, they listen to lawyers on each side of the case, and they check written records from the district court, because most of the cases come up from the district, or come down from the district court. Up. I don't know where I'm at. They come up from the district court. So they come up, and then the judges vote. And judges can reverse the district court's decision if they think the trial was unfair. So that's why they're higher up above the district courts, because they can change the decision. And so judges may send case back for a new trial, or if it's fair, the verdict will stand. And so the verdict is like the finding or the judgment of the court. So they can determine that, everything was fair, it was done well. And so the procedures are a series of steps followed in a regular order, so they're very procedural. They follow these steps and they interpret or tell the meaning of the law, and then they decide, should we reverse this decision or not? So we're going to do another quick review, write the best word to complete each sentence, and then do the what do you think. And I'm asking you, do you think the Court of Appeals should use a jury along with the 3 judges? So what is the Supreme Court? Who's in the Supreme Court? Well, again, it's the highest court in the nation, and its decisions are final. They're final. They cannot be appealed or heard again. So that's a lot of power. Right now, there are 9 members of the Supreme Court. Most cases reviewed by the Supreme Court come from a federal court of appeal. And remember, the federal court of appeal in that order of the 3 courts is right below the Supreme Court. And the federal court of appeal is right above the district courts. So they review special appeals court, review cases in those courts as well. The Supreme Court may also hear cases brought from a district court, so they could even be reviewed from the bottom. Often in these cases, an act of Congress was said to be unconstitutional by that court. So Congress, remember, they're the lawmakers. And so in a system of checks and balances, the Supreme Court can determine, you know what, Congress, your law is not following the Constitution. We have these values in place, and you cannot use this law. So someone has to challenge or question the law involved in a case before it can come to the Supreme Court. So someone actually has to raise their hand and speak up and say, this is not right. For instance, a lot of people with the Second Amendment are afraid of losing their rights. So you're probably going to see a lot of cases in the Supreme Court to determine, should there be restrictions or not? Are we violating the Second Amendment or not? In some cases, the Supreme Court has original jurisdiction, which means they can look at cases without being reviewed by a prior court. So usually this happens if it involves an ambassador or a minister or consul. So those are the ones that are supposed to be representing us and developing friendly relations in other countries. And if they blow it, they really blow it. They go before the Supreme Court. So again, the highest court in the nation is the Supreme Court. How does it work? What cases are reviewed in the Supreme Court? So I'm going to touch on 3 different avenues. An act by Congress was considered constitutional. Bam! Someone says something. This is non-constitutional. It comes from Federal Court of Appeal or Special Appeals. So that's one avenue. Someone challenges or questions the law involved in a case. Must be challenged in a case before it can come to the Supreme Court. So someone has to raise their hand and say, this is not right. This is violating the Constitution. Or the Supreme Court has original jurisdiction. And that happens when a state or a party is in a case, or a state is the party in a case, excuse me. The state is a party in a case. So a state is being sued, or an ambassador, minister, or consul. So how the Supreme Court works is it first decides whether to review a case. So the 9 justices will look over what the case was. Say it came from a district court, for instance. They'll review it and determine if it's really something they should look at. The Supreme Court makes a decision about the law involved. So they decide what law was enacted when this case was determined, when the verdict was determined. Rules whether law is unconstitutional. So they decide what law was broken in this case, and then they decide, was this law unconstitutional or not? So basically, they're looking at the law, not the person. Not whether the person was guilty or not. They're looking at whether the law that the person broke was a worthy law. If law is unconstitutional, it is no longer used. Okay? So it's out the door. So law is not permanent. It is ever-changing and fluid. There is one Chief Justice. The President appoints the justices for life. Okay, so for life these people are in. And the Senate must approve it. So the President can't just pick and choose whomever. And it's rare when a president does get the opportunity to choose a justice because it is for life. These are 9 people that are in there. So the Senate Judiciary Committee is in charge of approval. And remember, we reviewed some committees, I believe, earlier. They may be impeached. So if you really are not doing your job as a justice, you can be impeached or brought to trial if they're not following the ethics of their duties. So that is something to really take note of. So again, law is not permanent. So what happens during Supreme Court sessions? So sessions are work periods, and usually it starts the first Monday in October, and they work until June or July. And the justices in the first do 2 weeks. The 9 justices first do the following. They hold public sessions, or what they call sittings, and they listen to the facts of several cases. The Chief Justice sits in the center, and he or she keeps order. The lawyers from both sides speak their case, so they present the information that the justices need to hear. And then the justices will ask some probing questions to really get clear on what law was being enacted. Then the next 2 weeks, they study the facts. So they hear, they question, and then they study the facts. They provide briefs about the cases. Not the justices, the lawyers. They provide briefs about the cases. So what do I mean by briefs? They give more information, some facts about the cases, so the lawyers can understand even better. And then the period of study is called recess. So the justices go to recess, and it's not like kindergarten where you're playing on the playground. They're actually discussing and studying up on the law. They're digging out those big hefty books and critically examining what laws are in place and whether they're really valid or not. Then they do a rotation of study and recess, okay? So decisions made by a majority vote determine whether a case is going to be changed or not, whether the verdict is going to stand or not. So 6 justices must be present to vote, at least 6 of them. So sometimes the justices don't show up. So then an opinion is written explaining why the decision was made. So one of the justices will choose to write opinions that led to the conclusion that they came to. So they explain why this determination was made. And so it makes sense to people, so they understand the line of thinking the justices had. And then those opinions are published in something called United States Report. So if you're ever really bored, you can look up some of these opinions. And I did. I looked up a very interesting case. Although it was more of a state Supreme Court, they determined that, well, actually, I'm not going to share it right now. I'm sorry. Never mind. Okay, so I need your thoughts. I really want you to write down if you think the Supreme Court is too powerful. And I'm just going to pose some ideas for you to consider. There are 9 justices, right? There's 1 Chief Justice out of the 9. They're in there for life, and they're the Supreme Court, so they are the law of the land. They determine cases that have no, they're the final say, basically. And they can determine the direction of law. So do you think the Supreme Court is too powerful? And if not, explain. And if so, please explain. So what is judicial review? Well, as federal courts settle cases involving constitutional questions, like are we following it, they interpret the meaning of the Constitution. And why I said meaning is because, again, as we evolve, when we read the same words years later, it reads differently. As we mature, as we have more experience, and I mean we as a society, we mature together as well. So the meaning of the Constitution, though the words remain the same, although amendments may be added, the way we interpret it shifts. The Supreme Court plays a role in this process. The Supreme Court uses something called judicial review. Judicial review to interpret the Constitution. Under judicial review, the court can declare laws and actions. So they declare laws and actions of local, state, and national governments unconstitutional. So a local precinct may be doing something that is unconstitutional. Bam! Here comes the Supreme Court. Dun, da, 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 da. So before 1953, the Supreme Court followed a policy of judicial restraint. And remember, during the 50s, there was a lot more conservatism. So judicial restraint, again, like I said, we grow and evolve as a society. So during this time, in the 50s, judicial restraint made sense. Under this policy, U.S. courts did not interfere with decisions made by the legislative and executive branches. So they didn't really dabble or interfere with lawmaking or executing. Supporters of judicial restraint thought that appointed judges should not ever get involved with questions related to politics or social issues, which is a challenging thing to do because it seems like everything's political, everything's social. But at this time, they said hands off, and so they thought judges should not be policymakers or involved in that way. So instead, judges should limit their powers, they said, as stated by the Constitution of the United States in individual states. Then, under Chief Justice Earl Warren, he comes in 1953, and he lasts until 1969. The Supreme Court under him often practiced judicial activism. So now look at, we're evolved into the 60s. The state of mind during the 60s was much more revolutionary. So this meant the Supreme Court should shape social and political issues. So now they're starting to think, no, we have a say in social and political issues. And in 69, social and political conditions of the time tended to affect the Supreme Court in their uses and the way they use judicial review in interpreting the Constitution. So these are very fascinating things, and I want you to think about that. Where do you think the court is now? Can Supreme Court decisions change the Constitution? So we've been conveying that the Constitution is solid. You cannot change it. It's pretty much structured so that nothing will break it. Well, nothing does break it. However, like I said, things can subtly change through time and history. The Supreme Court decisions have brought about changes in the Constitution, and we're going to give you examples so you really understand what I'm talking about. For example, the Constitution states in Article 1, Section 9, that direct taxes must be apportioned according to the population of each state. What does that mean? What is that? Well, it means they should be given out and divided perfectly among the states. So basically our government was taxing each state according to the population. But then, whoa. In 1895, the Supreme Court ruled that income taxes were unconstitutional because they did not come evenly from each state. Because everyone makes money differently in each state, and as a result of this decision, the 16th Amendment was written, passed by all states, and added to the Constitution. So Congress was allowed to tax incomes without apportionment from the states. So basically the states aren't responsible for giving equal share. You know, when you pay your income taxes, and you do, every month a little bit's taken out. Now it doesn't involve the states, it just goes directly to our federal government. That's the 16th Amendment. Are Supreme Court decisions ever change? Yes! Yes, rarely, yes. As we evolve and become more educated, earlier decisions need to change. As an example, the issue of segregated schools separated African American children from white children. In the 1880s, many southern states set these schools up. And I'm going to explain this in the next slide. Are Supreme Court decisions ever changed? I'm asking you now. The Supreme Court can make a decision that is the opposite of an earlier decision. They can change things. This happened with the issue of segregated schools, like I said. So, now, people said that the segregated schools violated the 14th Amendment. The 14th Amendment states this. I'm going to just get directly from the 14th Amendment. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So in 1896, a case called for the end of segregated schools, because some people said these schools did not give equal education to all students. You've heard of the separate but equal clause. Well, no state should deprive a person of life, liberty, or property. And they're saying you are depriving people of this. Equal protection of the law. Equal. So that word equal was the driving force to get things done. So the Supreme Court had to decide whether these schools violated the Constitution. The court ruled in favor, believe it or not, of segregated schools in 1896. This court claimed that the schools were equal even though they were separate. They somehow were able to argue that fact. I'm going to go to the next slide and we're going to go into more detail. I'm going to make a point that laws change as we grow and learn from each other. We develop a better understanding of what right and wrong are. We demythologize people and their behaviors. And at this time, there were myths around African Americans. And as that myth began to demythologize because African Americans stood up to something they knew was inherently wrong, and they stopped internalizing oppression and believing what their oppressors were telling them, they forced people to question their outdated beliefs and become more knowledgeable and understanding. So, the 14th Amendment. In 1896, a case called for the end of segregated schools, and again I'm reviewing, the Supreme Court at the time ruled in favor. Finally, years later in 1954, now this is, remember, we just switched over to a new Chief Justice who was more of a judicial activist, okay? So they're more prepared now after the conservatism of the 50s. We're starting to shift now, and a case known as Brown versus Topeka Board of Education was heard. The double NAACP, which is also known as the National Association for the Advancement of Colored People, sued the Board of Education. The NAACP argued that the separate schools operating in Topeka were illegal. So law does not mean legal. When we say law, it's a powerful psychological impact on people. It makes people believe that what goes through a system is legal, and that is not always the case. So they said it is not legal. They claim that the schools for white students were better equipped and not equal. They were better equipped, more money to the white schools. That is not equality. And we still see this today. That's why I get fired up about this. There has to be schools now called magnet schools that force desegregation because there's still naturally a segregation happening due to poverty. So what happened in this case? Well, good news. They claim that the schools for white were better equipped, so they said that this went against the 14th Amendment. Life, liberty, pursuit of happiness, equality. In this case, the Supreme Court ruled that the segregated schools were indeed illegal because they did not follow the idea of equality stated in the 14th Amendment. The court said the schools should be changed because it's no longer, see how it is no longer legal. Suddenly the law is shifting. Why is it suddenly no longer legal to keep the schools segregated when it once was legal? I just want to put that out there. That's just interesting. It was a landmark decision in the Supreme Court. And as you see here in this photograph, the shift was challenging. Here you see a student, an African American student, going to a desegregated school, and you can see in the background this virulent woman yelling. So once a determination is made by the Supreme Court, the follow-through is not easy. So this is your final chapter review, and then if you answer to the best of your ability, you'll get full credit for this chapter. Write the word from the word bank that best completes each answer, and then you're going to go on to some more rich questions on the next slide, and then you'll be done. Thank you.